persons having anything to do before the Honorable Justices of the Supreme Judicial Court, sitting as the law court at Biddeford within and for the state of Maine, may come forth and declare it, and they shall be heard.
Good morning, you can be seated. And the matter before the court is State of Maine versus Townsend Thorndike. This is Cumberland 24-421. Council appear to be present. I'm assuming we are ready. We are being streamed live on the web, both by video and audio. If you would take this opportunity to introduce yourselves by saying your names for the record, together with the party you represent.
Good morning. Tyler Smith for Townsend Thorndike. Carlos Diaz for the state of Maine.
Thank you. Attorney Smith, if you're ready to proceed, we'd be happy to hear your argument this morning.
May it please the court, and good morning. This case is about checks and balances. The people's veto is a check on legislative power in the state of Maine. And as part of that process, the Constitution provides that any act of the legislature does not take effect for until 90 days after the legislature's adjournment. And the reason for that is to ensure that there is adequate time for a citizen-initiated people's veto petition to happen. It's only where an act is immediately necessary to prevent injury to the state that that constitutional requirement can be bypassed. Otherwise, the right of the people to seek a people's veto would be undermined. And that's why this case reaches so far. We're here on Section 358 and the amendments there too, but this case really is about separation of powers. It's about ensuring that the constitutional requirements for passing emergency legislation is followed. Now, in this case, the preamble merely states that some trial judges have had disagreements on the application of a new hearsay rule that had not existed for the last 200 years. It was not based on any particular problem resulting from any of those rulings, but just the fact that some judges have disagreed about whether that statute applies to pending cases. And that is not an emergency as defined by the Constitution. Especially so here because the law was already clear. This court decided Beeler before the legislation was passed, and Beeler pretty clearly states that under those circumstances, Section 358 would not apply to pending cases. Now, the other aspect of this case that we've raised in the brief concerning separations of powers is whether it was a violation of the separation of powers doctrine for the legislature to pass this act. And what's unique about this law is it applies to a closed class of people. Nobody new can ever enter the class of the people affected by Section 358. And in that sense, this case is much like the People v. Canister case that is discussed in the reply brief. And with that, I would waive any further uninterrupted time and welcome any questions.
Could the legislature have originally enacted Section 358 as emergency legislation?
If the preamble was sufficient at the time, yes.
And so if the legislature thought that there was an emergency with Section 358, then why isn't it constitutionally allowed for the legislature to enact a fix to the statute to make clear that's what they intended?
I think it would be permissible to do that, but that's not what happened in this case. What the problem that was cited in the preamble was that trial judges have disagreed about how Section 358 applies. It was not that trial judges are interpreting it differently than the legislature intended.
But that is what they said in the legislation, is that this is really a fix. We intended it to apply immediately from the beginning. I understand that's not in the preamble.
It's not in the preamble, and that the preamble is, of course, the controlling document in terms of whether the act actually passes muster as emergency legislation. And that's the constitutional requirement that the preamble must express the facts. It doesn't necessarily need to recite every single fact, but it needs to define them with such clarity.
Can we look outside the facts in the preamble and look at the context of the legislation itself? Or are you saying we are constrained to the four corners, the actual words of the preamble, and nothing beyond that?
I think in terms of whether it's an emergency, I think you need to look at the preamble, but there is a clarification with that, is that the specific emergency discussed here it's not really a factual situation, it's about an interpretation of law, which I think this court is well-suited to opine on.
But isn't the
Specifically-
emergency, if we look at the context, the emergency is the welfare of the children, the victims of these offenses, and that they will be harmed unless clarity is created quickly? Can't we look at that context as well as the facts alleged in the preamble?
I don't believe so, because the preamble does not state that that is the concern. The fact in the preamble that is of issue is that citizens rely on the legislature to enact statutes
Counsel,
that will be interpreted.
when you say
consistently.
preamble, are you talking about the entire preamble, or are you talking just about two paragraphs that were inserted into the overall preamble?
I'm talking about the paragraphs that were inserted related to this specific.
Why doesn't the whole preamble apply?
Well, because I think in context, it is clear that
Well,
the
if we're going by the
first four-
words, if we're going by the words of the preamble only, why don't we look at the whole thing?
Well, I think when you look at the first four paragraphs, though, and you look at the facts and travel of the way this was passed.
Yeah, paragraph 1 says, we made a mistake in the past, and we want to correct it, essentially.
Right, and that was what was present in the act initially, when it's,
It also says there are inconsistencies, conflicts, these create uncertainties and confusion. It's vitally necessary that these be resolved in order to prevent any hardship to citizens in Maine. Now, isn't calling children to the witness stand in these kinds of cases a hardship on them?
absolutely, and I will agree that if the preamble in this case said that we are concerned about harm to victims, that could be an emergency, but that's not what it says. And to your point, Your Honor, about inconsistencies, my question would be, what inconsistency? Where is there an inconsistency in Maine statutes regarding the application of Section
The
358?
error is that the intent was to have Section 358 apply immediately.
There's nothing in the preamble that
No.
suggests that. In fact, it says when you look at the sections of the preamble dealing with 358, it doesn't say we intended something different. It says that there are disparate trial court decisions and citizens rely on consistent interpretation. So the problem.
Counsel, how about all of the other parts of Chapter 646? How about each and every one of those other provisions? Are they invalid as well because they are not specifically referenced in the preamble?
No,
Like
no, of course.
changing the name from of Aspire Jobs to Aspire TANF? How's that an emergency?
That I'm not sure. That is
Well,
certainly something that.
I'll tell you why this comes about. Every year, the legislature passes an errors and omissions bill, and they always do it on an emergency basis. This is fairly routine stuff.
No, I agree, and I'm not sure if there's a case that has challenged that process, and perhaps that's a question for another day.
Well, you
But
talk
as to
about
this
you talk
specific
about
law-
separation of powers. I mean, shouldn't we be giving some deference to our co-equal branch and giving them some leeway to run their own business?
Absolutely, but this is a question of constitutional interpretation about what qualifies as an emergency, a situation where there needs to be immediate action to prevent harm to the state of Maine.
Well, let's say you're
And they-
right. Let's say you're right. It was emergency legislation. You get a new trial. Why doesn't the new rule apply in your new trial? All you said in your brief is, it's not fair. Is that really a basis for us to rule that an evidentiary rule should be ignored?
Your Honor, I think in this case, the facts and travel of it are suggestive that it would be appropriate for Mr. Thorndike to have a trial that is controlled by
What's your
the-
authority for that? What's your best case to support that?
I don't have a case on point. This is a very unique situation. I've not been able to find one. The remedy certainly is something that I struggled with when working on this brief and trying to determine how to frame that particular issue. But when we look at what happened here, we're on the eve of trial, the change to the law comes out, the trial is continued for reasons that are unrelated to this.
And he's
But
understandably
counsel-
upset. I mean, your client and you were probably understandably upset by the turn of events, but it wasn't personal. It wasn't like the legislature stepped in and said, oh, this trial is going forward, we need to stop this trial. There's nothing to suggest that was the case.
Well, there is something to suggest this is the case because the committee
That's your
hearing
second argument.
people were asking about.
But counsel, let me ask you a slightly different question. As you started off in your remarks, you said this is a rule of evidence. This is an evidentiary rule. Are evidentiary rules subject to the same retroactivity analysis as substantive rules? Or do they apply to cases pending when passed?
You mean, well, you're asking with respect to Section 358 if that is
Do we
controlled?
even go to an analysis, or do we just say it applies?
Well,
Because usually evidentiary rules, when changed, apply to pending cases.
no, I agree, but this isn't an evidentiary
Well,
rule
that's
in
what
the
you
sense
started
that-
your argument, is this is an evidentiary rule or standard.
Well, let me be more clear. It's a rule that applies to how evidence is handled in courts, but it's not a main rule of
It's
evidence.
whether it
is
No, I
should be
understand.
admitted. Why isn't it an evidentiary rule?
In a
Because it's
lowercase r, it's not a rule of evidence, I understand that. But don't we apply a different analysis with regard to whether a new statute applies as to whether it's a change in the substantive? In other words, if they change the offense, that clearly, you can't do that after the fact. But we may apply, can't we, procedural rules, evidentiary standards that change to pending cases?
I don't believe so, because this is a statute, and Title I, Section 302 deals with retroactivity of statutes and whether they apply to pending proceedings. And this court has interpreted Section 302 to hold that in this type of circumstance, the
Can
rule
I
would
take you,
not.
you only got less than a minute left. Can I take you back to Justice Connor's question? Let's say we accept your arguments, we vacate, remand for new trial, rewind to zero, basically. What would you say to the presiding judge when the judge says, all right, it's subject to this statute because the trial is taking place now? Is there any cogent or supported argument where you could say, no, you should not allow this?
I don't have a statute or a case that I can cite to, but as a general principle, Mr. Thorndike was deprived of the opportunity to object to the video on the basis of it being hearsay by virtue of Section 358. This court has issued a ruling in the hypothetical that that was unlawful because Section 358 was unconstitutionally passed as emergency legislation. And as a matter of fundamental fairness, the remedy on appeal should be to allow him to have a trial where that evidence won't be admitted. Thank you.
Thank you. Attorney Diaz.
May it please the court, the amendment of Section 358 met the constitutional requirements for emergency legislation. The preamble properly expressed the legislature's finding that an emergency existed, as well as the facts constituting that emergency. The preamble also expressed the legislature's finding that the amendment was immediately necessary in order to preserve public peace, health, or safety. In the words of the preamble, emergency enactment was vitally and immediately necessary to resolve inconsistencies and confusion in the application of the hearsay exception. Thorndike has failed to overcome the strong presumption that it was constitutional. This court must give great deference to the legislature's finding and its judgment. If the stated emergency could impact public peace, health, or safety, then we look no further. It is obvious that this law impacts public health or safety. 358 was designed both to protect young or disabled victims of sexual abuse from being re-traumatized on the witness stand and to protect the rights of the accused at trial. It strikes a balance between those competing interests to ensure sexual abuse trials are fair, which clearly implicates public health and safety. And the legislature expressly found that inconsistency in 358's application constituted an emergency, and it amended the statute to guarantee that it would apply to all cases, regardless of when the crime occurred or when it was charged. That amendment did not violate separation of powers. Both the judiciary and the legislature have authority over admissibility of evidence, as noted throughout our rules of evidence and through the many enacted statutes that govern evidence. Nor did the amended statute require the trial court to set aside its prior order. 358 does not require admission of a forensic interview video, instead leaving the final decision to the court. The trial court could have excluded the video if it was not relevant or unfairly prejudicial or cumulative or confusing. Thus, the amendment did not tie the court's hands. Nor was it a special or private law. As in the McImage case, this amendment created a general law that applies to all cases. In stark contrast, the Colorado and Hawaii cases that Thorndike relies on involved invalid special laws that could only apply to one or two persons, two capital defendants or one ferry company. And it is commendable that the Maine legislature responded promptly to address a real issue in real time, closing a loophole in the original law to ensure that all victims and all defendants have the protection of the statute. This court should affirm the judgment, and I welcome your questions.
If I understand your argument correctly, you're saying the legislature made a finding that an emergency exists, which is what's required. They recited some facts supporting it, and we basically, at that point, that's all we look at, and we don't second guess it?
There's a little bit of further inquiry. You've allowed yourself to look further into whether the type of emergency affects health, safety, or welfare. And that's it. As long as it states facts and declares an emergency that relates to health, safety, or welfare, we look no further. See Morris.
So how is the inconsistent on the issue of retroactivity, on the issue of the admissibility of some courts at trial are saying we're applying this, some courts say we aren't applying it. How is that, some courts are doing it differently? How is that affecting the peace, health, and safety such that there's an emergency?
Because the legislature intended 358 to protect all victims and all defendants. And it clearly acknowledged that had it thought of it, it would have emergency enacted the statute in its original form. That's why, as Justice Douglas pointed out, this amendment was done as an errors and omission bill, or part of a larger bill. And the legislature, in its emergency preamble, specifically said, this is an emergency because our exception to the hearsay rule is not being applied to all cases. Some victims and defendants are being left out and others are not, simply based on when the charge was filed.
But the legislature didn't take the additional step of explaining the harm that was caused by that, and I certainly understand your argument as to what that harm is, but can we draw the inference from the preamble?
Not only can you, but you're required to.
Under
All
what?
reasonable inferences, as long as the facts identify the nature of the emergency, which is inconsistent application of the hearsay rule in sexual abuse cases, and accept the fact that the legislature deemed that to be an emergency, we look no further. And we have to draw reasonable inferences based on the statutory context, the purpose of 358 as originally enacted.
But isn't the key word there reasonable inferences?
Yes.
There is some discretion that we have in looking at the language that's been put into the preamble to determine whether or not the facts that have been asserted actually reasonably lead to the inference that there's an emergency.
Thank you, Justice Lawrence, for focusing in on that point. I may have said reasonably, that's not what this court has said. This court has said in Morris, if any facts set forth in the emergency preamble could constitute an emergency relative to peace, health, or safety, we look no further. So there's not even an assessment of reasonableness. That would be second-guessing the legislature and its legislative function. Instead, all we look at is, could this emergency affect health, safety, or welfare?
Counsel, could I redirect you to the separation of powers argument
please.
for a moment? Suppose the prosecutor who was involved in this case went to the legislature, put the bill in, went before the Judiciary Committee, testified, and was successful in getting this particular bill passed and thereby going back, therefore being able to go back and use it in his or her trial. Does that seem proper to you? And isn't that effectively what happened here?
I appreciate the observation, and I think that's the strongest argument the defense has, or Mr. Thorndike has, that somehow this looks a little awkward because there was actual testimony before the legislature about a specific case.
More than
as
a
well as
little
another.
awkward.
Fair enough.
I mean, he's saying it's really essentially a special law.
And if the legislature had then enacted a law that was specific to and limited to the Thorndike case, or the other case in York County that they heard testimony on, then yes, we would have an unconstitutional private law. But what they actually did was take a law that created two classes, those that were pending when it was enacted and those were not, and eliminated that discrepancy. They did not create a special class. They eliminated a special class that was completely
But
arbitrary.
doesn't the legislature actually, or the amendment only apply to a very narrow class? In other words, it's not really going to have any effect going forward. It's just the folks who sort of fell into this accident of timing.
As written, the amendment itself applies to all cases, before or after this particular date, and regardless of when the conduct occurred. So it is written by the legislature to apply to all cases. Now, in application, maybe the only difference it makes is to however many cases there were that were pending at the time 358 was enacted. But again, we're not creating a special class, we're eliminating a special class, eliminating the class of cases that were pending when the original statute was enacted. That is not private or special legislation. That's creating a general law designed to protect everyone.
Is it saved by the fact that we know there were at least 2 cases as opposed to just 1?
It could be, and we don't know how many sex cases there were pending involving children or disabled adults at the time of the enactment. So we can't say it was just 2. We don't know how many there were.
My point being that the testimony came from at least 2 different.
There were references to 2 specific cases. And even if we just look at this one case, Judge French first ruled that it was admissible, then ruled that it was inadmissible, and then after, he reversed himself after the amendment. So even within the context of one case, there was confusion and inconsistency. Clearly, the legislature got it right when they said this is not what we intended. We wanted this exception to the hearsay rule to apply to everyone.
If the legislature states in the emergency preamble, we think there's an emergency here, we need to have this enacted as emergency legislation, is that enough to get it past the door? In your opening statement, you said the legislature makes a determination of emergency and you go from there.
It's not. It's not enough for the legislature to say, we find an emergency. They have to state the facts constituting the emergency, although they can do it in summary form. They don't have to provide all the details. And this court can second guess whether that is in fact a type of emergency that relates to health, safety, or welfare. That's it. But it's not enough for the legislature just to say, we find an emergency, therefore.
You said they have to find an emergency exists and state some facts supporting it.
And
that's
the
what our
emergency
case
has to relate to health, safety, or welfare.
Let me ask.
Can we look at the context of the legislation itself? If the
Absolutely.
legislation was something innocuous like changing the appearance of a license plate or something like that, and it would affect people because they have, vanity plates or something like that.
There are strong opinions about those vanity.
All right, that's probably a bad, that's a bad
I appreciate
example.
the
But
question.
we can look behind the legislation and decide for ourselves in context whether it really is an emergency affecting the welfare of the people.
Not only can we, but we have to, because we have to give all inferences that are permissible to support the finding that there is an emergency affecting health, safety, or welfare. And this is a statute that deals with children and disabled adults who are sexually abused, allegedly.
Let me ask you the same question I asked Attorney Smith. Do we even have to worry about the retroactivity and whether it applies to cases pending at that point?
Separate issue, and I appreciate, Justice Stanfield, your questions about procedural versus substantive changes. If we're talking about ex post facto analysis, then we focus on that difference, procedural versus substantive. This isn't really an ex post facto law.
No, but it's a rule of evidence, and
It is a rule of
traditionally,
evidence.
those are applied to any cases that are pending, are they not?
I would follow your logic that less worry is necessary to the extent that the court has any at all. This is an evidentiary statute. Doesn't affect substantive rights.
Counsel, do you think the Payne decision was correctly decided?
Yes, I do, Your Honor. And that's because in Payne, they invalidated the prostitution law back in 1919 because, and they said this specifically, this court said this specifically because there was absolutely no statement of facts. And there were no facts even suggestive of an emergency. So yes, that was correctly decided, oh so long ago. Here, we have a statement of facts, and they clearly indicate an emergency. Inconsistency that leaves some victims and defendants in sexual abuse cases left out in the cold.
Well, didn't the preamble in that case refer to the necessity of preserving public health and the enactment of more stringent laws prohibiting prostitution, lewdness, et cetera, is an emergency?
It did, and if you want to parse through the facts versus the holding, you're welcome to, and then maybe you do find that Payne was wrong. But the holding of Payne says It contains no statement of facts, no statement of facts. Now,
That's why I asked if
Maybe it
you
did.
thought it was, that's why I asked if you thought it was wrongly
all right,
decided.
I think it was wrong, but I think the holding is consistent. The holding is consistent because it says if you make no statement of facts, that's invalid.
So if Payne was wrongly decided, is there any precedent at all here in support of the appellant's position?
Well, Payne is the case that every defense attorney who wants to raise this issue goes to because it's just about the only support that they have. And yes, if it was wrongly decided, you've taken away the ground upon which that argument stands. Any further questions?
There don't appear to be.
Thank you.
Thank you.
Mr.
And
Smith, do you think Payne was wrongly decided?
No. So I was planning to talk about Payne when I came up, so it was a well-timed discussion. And actually, Payne was the case I was thinking of earlier in the argument in response to Justice Lopez's question about whether we can draw the inferences that the state is asking this court to draw about the harm to victims. And my response is you simply can't. That is exactly what happened in the holding and in the reasoning of Payne, where the government made a number of arguments about the benefits of the law, the reasons behind it, and what this court said is, look, those are not in the preamble, and they may be convincing.
But we later said in Eaton that you can look at implied facts, or you can look at the context, essentially. I mean, Eaton was the Dragger case, right? The emergency legislation that prohibited dragging near an island, and the concern was they didn't want to cut the power, wanted to protect the power of the island, but nowhere in the preamble was that mentioned.
Right, but in this case, the preamble says what the nature of the emergency is, and it's that people rely on consistently interpreted statutes, nothing about harm to victims, nothing about due process, nothing about the actual substance of the law. It was
But given
just about...
given the protective purposes of the law, you have to establish that there is no scenario under which inconsistent interpretation could create an emergency, don't you?
Well, I think it's in the context of this case where you're talking about a law that deals with hearsay, admission of hearsay, a new hearsay exception essentially that's been passed by statute, and whether inconsistent application of that in the situation where there's actually a law court case that pretty directly controls the question, whether
But
that is an
to uphold
emergency.
your argument, we would have to decide that there is no set of circumstances under which the facts set forth in the preamble could constitute an emergency, right?
No, I agree with that. And the question here is about this specific law and whether inconsistent interpretations of this specific law could qualify as an emergency. And
Can we
again,
look at the
that's-
protective purposes of the law in determining that?
I don't believe you can, because the preamble does not state that that is the issue. And I fully agree that if the preamble said, not that we're concerned about inconsistency, but we're concerned about harm to crime victims, then that would be sufficient. But that's not the type,
But we can't look at the preamble in a vacuum. I mean, we certainly have to look at the preamble at least with the context of the law that is actually being passed, don't we?
Well, the legislature explains what it is. It talks about that it establishes a hearsay rule that allows for the admission of these interviews so long as due process protections are diligently followed. As my friend on the other side said, this was a balancing issue. There was testimony on both sides, and the legislature made a balancing call.
Thank you. And thank you for the argument this morning, counsel. As is our usual practice, we will be taking the matter under advisement to issue a written decision in due course. And with that, we'll be in recess on this matter.
All rise.
Good morning, you can be seated. The next matter scheduled before the court is State of Maine versus Kyle Fitzgerald. This is Cumberland 24-381. Before we begin, we'll welcome the students from Gorham, who I know have joined us here this morning. Welcome to a session of the Maine Supreme Judicial Court. I'm Chief Justice Stanfill. And I will also ask counsel to identify themselves for the record. We are being streamed on the web by both video and audio. And counsel, I think you actually are the appellant in this case.
Yes, Carlos Diaz for the state of Maine. Thank you. Dan Wentworth for Ms. Fitzgerald.
Thank you. And Attorney Diaz, if you wish to be heard, we'd be happy to hear your argument.
May it please the court, the suppression order rests on 3 incorrect legal conclusions. First, there was probable cause before the dog entered the car. Second, the dog's entry did not violate the Fourth Amendment. Third, suppression was not warranted because there was no police misconduct. The court found reasonable suspicion based on the motorist's nervous behavior, contradictory statements, and evasiveness, plus the fact that there was an arrest warrant for the absent car owner. The court also found probable cause existed as soon as the dog, quote, got all excited and showed telltale signs it smelled drugs, like hard pulling, the head snap, and the tail wagging. But based on the video and the handler's uncontroverted testimony, those signs were evident before the dog entered the car. Also, under the instinctive entry exception, there is no Fourth Amendment violation if a drug dog enters an open car on its own without being directed, encouraged, or trained to do so. That narrow exception has been unanimously recognized by every federal court of appeals that has ruled on it, all 7 of them. And it is still good law after Jones and Jardines because a dog's unintended entry is not a deliberate police trespass. Indeed, federal and state courts continue to apply the instinctive entry exception to this day. But instead, this court, the trial court, followed rogue opinions from a lone federal district court judge in Iowa and the state Supreme Court of Idaho. With due respect, on an issue of federal law, the unanimous opinions of the federal appellate courts carry more weight. Also, those 2 cases are factually unlike this case, because there the police actually helped the dogs to enter the cars. In the Iowa case, Buescher, the dog was trained to enter the car. And in the Idaho case, Randall, the handler helped the dog by giving it a boost into the car. Whereas here, the court found the police did not train, direct, or help the dog to enter the car, nor did they intend for it to do so. The court found that they did not intend it. Also, the Idaho Supreme Court noted there would be no Fourth Amendment violation if that dog had shown signs that it smelled drugs before it entered the car, like in this case. And there's no basis to suppress evidence without police misconduct. The police followed the letter of the law based on existing precedent, and the court found they were professional and courteous, did not cause the occupants to leave the doors open, and neither caused nor intended for the dog to enter. Yet the court decided suppression was warranted, merely because the police were in control of the situation. That is not the correct legal standard for suppression, and it did not warrant suppression of evidence in this case. Because the court misapplied the law, you should reverse.
Counsel, I see that the green light is on. It seems that you finished your opening remarks in any event. In this case, the police pulled over the defendant's vehicle, or a vehicle that was being operated by the defendant, right? And it was
Correct.
pulled over for essentially observed traffic infractions.
Yes, a seatbelt violation and other things.
Yeah, and that was investigated once pulled over. And then, having completed that investigation, the occupants of the car were held at the side of the road for how much longer after?
So it took 43 minutes to finally get the identity confirmed for the
For
rear
Mr.
passenger
Early.
with a seatbelt violation, Mr. Early. 34 minutes later, the dog sniff occurred. The dog arrived and they did the sniff immediately.
Okay.
So an additional 34 minutes.
And do you agree that under Rodriguez versus the United States, in order to hold the people there beyond the time that was necessary to accomplish the investigation of the traffic stops, that there had to be a reasonable, articulable suspicion of illegal activity?
Correct.
And the trial court in this case said there was.
Yes.
Do you agree that we can review that determination at de novo as to whether the facts, as found by the trial court, indeed constitute illegal reasonable, articulable suspicion of illegal activity?
I do.
Would you address how it possibly can constitute that?
Sure.
There was, essentially, they acted suspiciously. I mean, we have said that that's not enough.
Well, the standard is reasonable articulable suspicion.
More
That's the
than a real
Rodriguez standard.
hunch, more than a hunch.
Yes, more than a hunch. And here we have nervous behavior. If you want, I can go through the details of it, but as you said, we are adopting the court's findings. because they're
Absolutely.
supported by
And when you
evidence.
said reasonable articulable suspicion, when you finish that, of what? Reasonable articulable suspicion that,
So
What?
you have four motorists, two from in-state, two from out-of-state. They admit that they're traveling interstate. They're illegally transporting 2-week-old puppies. They're giving evasive behavior and conduct. They're refusing to identify themselves. They're making statements that they all know each other, and yet they don't even know each other's names, and one of them denies knowing
But they
the
did
other.
identify themselves, and then that was, they did. And after that was even checked, and they found the information, the officer found the information, so I'm not talking about how long it took to get that straightened out. But they were continued to be held after that. And we've said that it can't just be an unsubstantiated hunch, fitting drug courier profile, things like that is not enough. There have to be actual facts that would lead to reliable information to make you suspect
Right.
an assertion of illegality.
So in Reed, United States versus Reed and State versus Ireland, we have held that probable cause can be based on nervousness, evasive behavior, and furtiveness, all of which were present here. And here we've got...
Probable cause can be based on that?
Probable cause. And those cases are cited in my brief, United States versus Reed and Ireland. Not alone, but viewed in totality.
Right,
And
not
here-
alone, that's the problem.
And here we have someone who's driving unusually slowly on the highway, even though that person is tailgating a truck, staring straight ahead, not looking at the police cruiser that's alongside her vehicle for over a minute, contradicts herself about where the men were picked up, doesn't seem to even know their out-of-state destination.
Counsel, sorry to interrupt you,
Yes.
but, so the extension of the stop here was specifically to bring a drug canine, correct?
After Early was identified, there was a 34-minute
Right.
extension for that
So
purpose, yes.
they're investigating drug activity, so do you agree that there needs to be reasonable articulable suspicion of drug activity, drug trafficking specifically, as opposed to just some general concern about criminal activity?
Thank you for raising the point. No, it does not have to be drug-specific activity, although that was present here. And if
but
I...
getting back to my original question, articulable suspicion of what? So we have the officer there, what is he suspecting? What can he articulate that he's suspecting? It's drugs, isn't it?
Yes.
Okay.
And
So people who
Justice
drive
McKeon
with
found-
straight arm, and they offer evasive questions, and they've got illegal puppies in the car, that leads to a suspicion that drug transactions are taking place.
There's more than that. They're giving contradictory statements about how long and whether they even know each other. They're also, Early in the back seat is avoiding being identified by pretending to be asleep, refusing to speak up even after he's repeatedly asked to state his name, misspelling his name repeatedly without the apostrophe. All of those are indications that he's trying to avoid being investigated or
For drugs.
For drugs.
So anybody who acts this way is going to be subject to...
But coming back to Justice Lopez's point, it doesn't necessarily have to be a drug suspicion, although that's present here. We also have other criminal activities, such as transporting the illegal puppies. 2 weeks old is illegal under Maine, New Hampshire, or Massachusetts law.
And that
And
might
how does-
explain why they were evasive and nervous.
Unlikely. Since
And
the first
you've
thing they said to
investigated, the
since
officers investigated
the-
that
the-
before they extend the stop for
They
the
immediately
drug
told
sniff.
the officer, these are 2-week-old puppies. That doesn't seem to be the basis for their evasiveness
But
and
how does
nervousness.
waiting for the drug dog help you investigate the illegal puppies? I guess that's the link I'm struggling with.
The officer had suspicion of illegal drug activity. He wasn't particularly concerned about the puppies.
Is there anything in the record about this is a known corridor for transportation of drugs? Or-
Nothing in the record about that. Just their statements that they were heading out of state, although They gave differing accounts of what state they were going to, and the driver didn't
So
even
heading
seem to
out of
know.
state equates to drug activity?
No. Driving very slowly, giving evasive answers, contradicting each other.
Driving
about the-
slowly while tailgating another vehicle apparently is driving the same speed as the other vehicle.
Oh, they're on the highway. They could easily have passed the other vehicle, and the other vehicle had slowed down because
Why
there
would
was a
they
police
have to
cruiser.
pass the other vehicle?
They don't. They don't.
I see you have 3 minutes left.
And you're getting
And I-
frustrated.
And I just, well, no, I'm not observing that, but I just want to take you to the other issue, which is probable cause for the search. We can all agree that a vehicle on the highway, articulable suspicion will allow examination of the outside of the car, but to get to the interior of the car, there must be probable cause.
Correct.
And the drug sniffing dog was brought in. And I'm just looking at the court's findings about that. The court says there was not enough time for the officer to conclude that the dog's behaviors indicated that it had detected drugs before the dog entered the car. Once the dog was in the car, rummaging around for a few seconds, the officer had the time to observe those behaviors. The officer signaled that he had seen enough. There's probable cause afterwards. So, and we've seen the video. It all happens very fast. The dog sniffs the front of the car. He comes around to the side where the door is open. And the dog plunges in, and after a couple seconds, the officer says, okay, you're good, probable cause. At that point, the court was not satisfied that probable cause existed before the entry was made into the car.
And that was a legal conclusion, which I submit was incorrect.
But he made a finding that there wasn't enough time for the officer to make that conclusion.
He did. And if you compare this case to Polita Ayala, then I think you'll find that the federal court's logic holds and the state court's logic does not. In reviewing the court's legal conclusion, we review de novo. 11 courts of appeal, including the 8th Circuit in Polita Ayala, said if the dog shows signs immediately before entering the car, that's enough.
But isn't that, aren't there sort of both aspects to that conclusion, both a legal and a factual? In other words, that may be enough. If the trial judge agrees that the dog showed those signs before entering the vehicle, under that may, as a matter of law, be enough. But the trial court here said there really, didn't he also, I mean, it seems a little mixed to me.
It is mixed.
Essentially find as a matter of fact that he doesn't believe that the officer on scene actually understood that the dog had alerted before entering the vehicle?
So the judge factually found those signs were present before the dog entered, a couple of seconds before, and the video confirms that, as does the officer's testimony, and made the legal conclusion that that the officer could not have reached the conclusion that there was probable cause. It's an objective standard.
But it wasn't that he couldn't have found probable cause. It wasn't enough time for the officer to observe that there were indications
And
of
yet
an
we-
alert. So it has to be observable by the objectively reasonable officer, right, to be part
Yes.
of the PC analysis?
Exactly, and we can observe it. It's in the video. Before the dog enters,
Well, do
you
we
got the head snap.
substitute our judgment do we independently examine videos if the trial judge finds
On an
one
issue of
way?
law about whether objectively probable cause existed before the dog entered, yes, this is
But is
de
it
novo
based
review.
solely on the video, or is it also based on the officer's testimony?
There was no contradictory testimony. The officer said those signs were exhibited before, and the court found those signs were exhibited before the dog entered.
Chief, may I have
Yeah.
leave to ask one
Go ahead.
question, even though the time's expired?
Go ahead.
I note here that you requested that the court make some findings of fact, and you asked that the court find that the dog displayed sufficient indicia that it detected the odor of drugs prior to entering the vehicle to establish probable cause. Those indicia included deep nasal exchanges, salivating, pulling the tail, and tail wagging. You were asking the court to make some findings of fact. The court declined to make that, didn't make that finding of fact, and now you're characterizing it as a decision, as a conclusion of law rather than a finding of fact.
The court found that those signs were exhibited. The question is at what point? The video and uncontroverted testimony irrefutably show those signs were exhibited before. The rest is just de novo review of whether that fact before entry established probable cause. And Polito Alaya and the other 7 Federal Court of Appeals decisions say that it did. Thank you.
Thank you, counsel. And Attorney Wentworth, be happy to hear your argument.
May it please the court. Good morning, Your Honors. So, based on the sort of discussion about the facts that was just had, I won't go into those as much, but I did want to go over the state's assertion that there's sort of unanimity among federal courts about this issue, about the instinctive entry. So I wrote in my brief that the cases that they cited, only one of them actually addressed Jones and Jardines, and about half of them were pre-Jones and Jardines. And sort of in response to that, in their reply brief, they say they cite multiple, about 8 post-2013 cases related to this instinctive entry, saying that numerous federal and state courts continue to recognize the instinctive entry exception, including opinions that expressly distinguish Jones and Jardines. And then there's a footnote that cites those cases. And if you actually go through those cases, they don't really stand for that proposition. Those cases are all easily distinguishable from the case we have here. For example, the first case, United States v. Shen, again, that case does not address or cite Jones or Jardines. So it doesn't engage in the analysis of whether or not this was a trespass and whether or not under Jones and Jardines that stop should have been invalidated. Additionally, United States v. Keller, in that case, the dog touched the exterior of the vehicle. It did not enter the interior of the vehicle. And so again, it doesn't really get to the point of this case where we have the entire head and half of the body of the dog into the vehicle. In United States v. Cordero, the dog alerted immediately upon being deployed prior to its entry onto the interior. So again, not applicable here. Probable cause was established prior to the dog's entry into the vehicle. In United States v. Trapp, the defendant was a passenger in a taxi cab, and there seemed to be some dispute about whether or not that defendant even had standing. But regardless, the taxi cab driver provided consent to search the vehicle. So it was a consent search when the dog jumped into the vehicle. In United States v. Zaborski, it appeared that the dog never actually went through the window, and so it was a little unclear from that opinion, but again, it doesn't appear that the dog actually made entry into the vehicle. In United States v. Felmy, the court actually says that they were, quote, unconvinced that the sniff at issue constituted an invasion of the vehicle. And they then go on to say that part of their reason of that is it was just sort of the snout of the dog, quote, it was the snout, and then not her entire head or body. Here we have the entire head of the dog and half of the body.
Green light on. So can I take you to whether the stop was extended too long?
That is...
At what point in the stop would you say it went over the line? At what time?
As soon as they get Jawan Early's name back on file, I believe the stop is then extended too far. They need to, at that point, issue a traffic citation to Ms. Fitzgerald and Mr. Early if they're going to, or they have to, or have some other reasonable suspicion to detain the party.
How do you respond to the state's argument that the dog alerted outside the car, in other words, before sticking its head into the interior?
I think Justice Meade sort of touched on it in the state or the trial court's findings of fact. And what he concluded was that it was less, quote, it was less than a second between the time the dog moved to go under the door and the dog was in the car. I cannot find that during that split second, the officer observed deep nasal exchanges or other conduct that gave probable cause to search the car before the dog broke the plane.
So let me ask you the question about whether the policeman had to observe it. And let me give you a hypothetical, and you don't have to respond that it's not this case, because it's a hypothetical.
Sure.
So the policeman is doing exactly what he's doing here, but he looks away. And the camera clearly shows that there's lots of signaling going on before the dog enters. The policeman, the question isn't whether the policeman has observed it. The question is, in fact, was there signaling? And in this case, did the court ever really make a finding on whether there was signaling? All the court did was say the policeman didn't have time to see it. Isn't there a difference between the two?
I don't think so, Your Honor, because it's what in a reasonable officer under the circumstances would do. And if the officer didn't make those observations, then he's basing his determination to search or detain on information he didn't
So
actually
you're saying
have.
that in the hypothetical I gave, and he's looking the other way, so he hasn't seen that there's all this signaling going on, and he lets and the dog goes in, that would be a problem?
I think so, because he didn't have that information. It's what information the officer had at the time of the violation. So I think that would be a
But it's an
constitutional
objective
problem.
test, isn't it? You look at objectively what information was there for the officer to perceive, don't you?
No, I think it's what the officer knows at the time.
Following up on those questions, the court made a finding here that probable cause didn't exist outside the car. And as you know, it's a big difference whether we're looking at a finding of fact or a conclusion of law. In this case, the state has said, we're not challenging any facts, we're not challenging any facts, but that was a conclusion of law that the court made there, which would give us an opportunity to take a fresh look at it. We have the video and all the rest here. Did the court make a finding of fact or a conclusion of law regarding probable cause, and whether it existed before the dog entered the car?
I think the court made a finding of fact. It made a finding of fact that prior to its entry, the dog had not exhibited enough indicia of drug trafficking or
So
drugs.
if it's a finding of fact, we defer to that because it's unchallenged. Is that the end, is that the end of the road?
Well, obviously, if I think it's a clear error standard, I don't think that that finding is a clear error. But yes, that would be the end of the road as to that inquiry. And then the inquiry is whether or not this instinctive entry exception exists, which in our position is that it does not.
Well, the law is kind of all over the place since Jones and Jardines, correct, on the instinctive exception to the hearsay?
I don't really think it is. In fact, in State v. Bowler, the dissent in that case sort of addressed this.
Let's assume it is. If the authority is split, what about the argument that the state has made about there's no police misconduct and therefore there should be a good faith exception that would allow this to come in?
I don't think so, because Illinois v. Cabell is very on point with here, and that's the case that the trial court relied on, that an exterior sniff is really is not a search, and that these officers should have been familiar with that case. I think that case is very clear that
But if the law is kind of all over the place as to whether an instinctive jump into the car is okay or not, does that mean that there isn't any misconduct, so there should be a good faith exception?
Well,
they're doing everything that at least some courts say is okay.
Let's assume, and I think it's a big assumption, that the officers in this case knew about this instinctive entry exception. And let's pretend that it does actually exist. I don't think it actually that this case even falls under it. And I think it's similar to the Campbell case and the Winningham case, where officers facilitated this. In the Campbell case, it was...
I know you're headed with that. Did the officers here have a duty to close the doors before the dog came?
I think that they cannot facilitate.
They didn't do anything.
Entry.
They didn't facilitate it.
Well, they asked the individuals to step out of the car.
Yep.
We're talking about a two-door coupe where there's two people in the back, so those people need to step out. It's unlikely that they're going to close the door behind them, the passengers. They also asked and requested that they take the puppies out of the car. They now have a basket of puppies that they're dealing with.
So do you want us to rule that officers have to close the door every time there's a vehicle search?
Or they have to prevent the dog from going in. The dog was on a leash and could
But
have easily...
closing the door can add to the smell. I mean, it can be, there have been case law that say, don't close those doors if somebody else opens them, because of the effect that closing the door can increase the smell. So if they don't tell the passengers when they're getting out to close the door or leave it open, how are they facilitating?
Well, again, I think that by instructing them to leave, they're facilitating that, and that was also what was ruled in Campbell. I also think that they are in control of the dog. We're pretending that this is a highly trained canine
That dog seemed awfully excited in the video, and it went under the door. I mean, what was the policeman supposed to stop him as a part of the instinctive jump? Because it doesn't, does the instinctive jump exception require the policeman to try to stop the dog?
I think the Fourth Amendment requires that officers don't violate and trespass on the property.
Would the
And
argument?
that's really where you're going, right, with the reason of the exclusionary rule. It's not a matter of whether, whether instinctive entry of a dog might somehow be the issue. It's really that they know they cannot enter the car without probable cause. That's really the reason you're suggesting, isn't it, that the
It is.
exclusionary rule should apply? That's a separate question as to whether, how they entered the car here, whether they entered the car, whether it was preventable, all those other things, but the exclusionary rule would apply from your perspective because they know they can't go into the car without probable cause.
Exactly. And again, I think Jones and Jardines make it clear that we're trying to, that this sort of reaffirming of the trespassory case
So you're saying
law-
that the instinctive jump by the dog exception no longer exists after Jones and Jardines? Because if it did exist, then we'd have to look at these issues.
I think it was questionable whether it existed at the time of United States v. Stone. I think certainly after Jones and Jardines, it does not exist.
Even though there's some case law that says it does exist, but you're saying that shouldn't affect our analysis here.
Well, I think that case law, again, as I suggested, that case law is not really on point. It's oftentimes sort of an incidental contact with the exterior of the vehicle, or sort of so de minimis that the courts have ruled that's not actually a trespass.
I'm going to ask a question to your opponent in just a moment, but if, and this is not the case, I'm not suggesting any misbehavior or improper conduct by the officers, but in a hypothetical case, if there were some really savvy officers who realized a dog was coming, and the doors are open thinking, this is great, that dog is going to go surging right into the car. It's going to be instinctive, it's going to happen. We're going to get the interior searched no matter what. Is that fear alone sufficient to bring this under the umbrella of the exclusionary rule, which is really intended to go forward to discourage inappropriate action by the officers?
I think so, and certainly after this case, I suspect Trooper Fancy will make sure that the doors are closed and the dog is not going to jump into other suspects' cars because of this ruling. So I think the exclusionary rule will do its job in this case.
Is it your position that the court found that the dog didn't indicate? Or is it your position that the court made the finding that the officer couldn't see the dog indicating before it entered the vehicle?
It was our position at the trial court that the dog never actually even established probable cause because it didn't give its trained alert indication. From our perspective, the officer testified at the hearing that it was really only he who could interpret the dog's sort of the salivating, the just noticeable differences, that those were for drugs rather than for some other reason, because dogs are going to be dogs, and regardless of how trained they are, they will in fact get excited when they smell, for example, puppies. And so what our contention is that if that officer is the only one who can interpret those signs, that there is no objective way for a court to analyze that. The objective signaling of probable cause is the alert indication. So that was our position at the trial court. Obviously, the trial court did not agree with us on that point, so we didn't focus on it, but that's still my position. And if there are no further questions, then I'll
There don't
cede my
appear to
time.
be.
Thank you, Your Honors.
Attorney Diaz, you reserve 3 minutes for rebuttal.
Thank you, Your Honor.
Isn't the real question here whether if the police use a drug dog or a technical device, whatever it happens to be, to facilitate their determination of probable cause, they have to use it in a way that doesn't infringe on Fourth Amendment rights?
Yes.
Meaning, in this case, keep control of the dog so it doesn't enter the car, so that it's clear whether the dog has signaled the presence of drugs from outside the car.
Yes, and if in this case, the judge found that the police officers deliberately used the dog to enter the car, like in your scenario, Justice Meade, end of discussion.
But the judge did find that the police officer failed to keep the finding is not
Finding was that he
entirely
was in
clear.
control of the situation.
Failed to maintain control of the dog.
I don't know, he didn't make that finding, but he found that the police were in control of the situation
Is that
and
an
allowed the
issue?
dog to enter.
I mean, is that what it turns on?
No,
In
it
other
turns
words,
on-
whether an officer could have kept the dog? I mean, at some point, you know,
Under Jones and Jardines and the unanimous federal courts, it turns on whether there's deliberate police misconduct. And here, the court found there was not.
But does it make a difference that there's a finding that the officer didn't make any effort to get the dog out of the car? So in some of the other cases where the instinctive entry exception has been applied, assuming we were to recognize that you have a snout briefly going in the window or something like that, here the dog is, you know, halfway in the car, rummaging around for quite a long time. The officer appears to wait for the final alert and then say, you're good.
It doesn't make a difference because at that point, probable cause was already established. It was established at the moment when a trained drug dog started intently pulling towards the open doorway. That's when PC existed. At that point, entry was lawful, and there's nothing wrong with them allowing the dog to keep sniffing around because they had probable cause.
can you, I think I understand the answer to these questions, but I want to make sure. Do you agree that first, there had to be reasonable articulable suspicion in order to extend the stop beyond once they identified Mr. Early?
I do, and I just want to come
Okay.
back to that. If
I was going to say, well, let me finish the second part of my question, which is, and do you agree, but for the instinctive entry exception, which you are arguing, otherwise there needs to be probable cause in order to enter, as a general proposition, the
I do
car?
agree.
Okay,
I
I
do
just
agree.
wanted to make sure.
Yeah, and the reason that's not the governing standard here is because this was not deliberate police misconduct.
I understand what you're arguing in response to that.
With regard to the issue of whether you can review reasonable suspicion, I addressed that in my reply brief, footnote 14. Because it's an alternative basis to justify suppression, I think it's fair game. So I do concede that. With regard to some of the other issues that was raised, final indication, the absence of final indication here is not significant because dogs are trained to give final indication when they locate the source of the odor.
And that was not the basis, really, of the trial court's finding below.
Right. The judge rejected the final indication argument. And footnotes 26 in my main brief and 8 in my reply brief give you a host of post-Jardines and Jones cases saying the instinctive entry exception is still good law. As far as the duty to close the doors, if I may,
Go ahead, finish.
footnote 25 in my brief gives you a host of cases saying the police are under no duty to close the doors.
Thank you.
And actually, if you look at the video, you'll see that the occupants closed the doors on 3 other occasions during the traffic stop.
Thank you.
Thank you very much.
As is our usual practice, then, we will take this matter under advisement and issue a written decision in due course. Before we take a recess, we have students here, and when we frequently, usually in October of every year, go and make arguments, do arguments actually at schools. And when we do that, the attorneys answer questions afterwards while we're in recess. We can't. But I would invite, if you're willing, counsel may be able to answer for a few minutes while we're in recess. The next case isn't until 11, whatever it is, 11:30. May be willing to answer a few questions if the students have them, and I know there's some other attorneys in the room as well. So sorry to put you on the spot, but if you're willing, I'm sure that would be appreciated.
We actually introduced ourselves before the argument.
Okay, that's great. So, thank you. I hope this provided a little bit of a glimpse for the students who are here, at least into the workings of the Supreme Court. And with that, we'll be in recess.
All rise. We are in recess.
Good morning, you can be seated. And the matter before the court is Saginaw 24-362, State of Maine versus Kenneth Chase Jr. We are being streamed on the web, both by video and audio. If counsel would identify yourselves by saying your names for the record, together with the party you represent.
Good morning, Maureen McNamara for the appellant, Kenneth Chase Jr.
Good morning, Valerie Adams for the state of Maine.
Thank you. And with that, Attorney McNamara, if you're ready to proceed, we'd be happy to hear your argument.
Thank you. May it please the court, counselor. A specific unanimity instruction forces jurors to look for concrete, particularized evidence.
I note that the green light is on. In this case, we can, assuming it would have been appropriate, obvious, to have given one. The question really is whether a specific unanimity instruction was required. What is our standard of review? I mean, the state is arguing that it's really waived here because it was neither requested and indeed there was an agreement with the instructions as given.
I think there was a base statement that there were no objections to the instructions. So that's the basis. We have obvious error here. That's the argument. We disagree with the state's contention that this is waiver.
Should we be saying that it is waiver when it comes to instructions? The usual thing that happens is counsel have the opportunity to request whatever instructions they care to instruct, and then at some point, when they're finalized by the judge says, are they acceptable? And you do it even after the actual instruction, usually is sidebar. If the attorney says they're acceptable, is that waiver?
No, it's not. And what that would do, I think I put this in the brief, it's going to incentivize defense attorneys saying, I'm not sure, Your Honor, if there is something, I have just missed it. I don't think this court would want to be incentivizing the lack of forthrightness and help in those
If
situations.
the lawyer says, I'm not sure, isn't the next question, okay, what is the issue? And wouldn't the lawyer then have to identify what problem there was to the jury instruction?
No, I think what the defense counsel and what would be advised to defense counsel going forward if situations like this is held to be a waiver is that a defense lawyer would say, Your Honor, I haven't caught it now, but if there is an error with those instructions, it's not a strategic decision for me to omit the request for that.
You think that would work?
I think that what we're talking about, though, is the slim basis that on a record like this, a statement like this is an affirmative waiver, a knowing waiver. Rule 52B requires knowing waiver, and that's because an error needs to be brought to a court's attention. If it's not brought to the court's attention, this court can still recognize obvious error.
But it's defense counsel's job, isn't it, at that point, to request what instructions are appropriate?
Absolutely, as it is also the judge's job and the prosecutor's job. And this is why we have language in the obvious error standard that we can recognize error when counsel is simply derelict for not asking for it. I think in situations like this, which may be distinguishable from other situations, there is simply no good basis. There's no reasonable basis to not request a specific unanimity instruction.
But we also have some case law that says you have to request it. Like Russell says ordinarily the failure to affirmatively request the instruction. And aside from Alexander, there's Fortune. So what do we do about that precedent?
Well, the Fortune case, I don't think has that statement about affirmative
On
requesting.
request, jury should be instructed.
And I think that's different, though, than waiver. Yes, when you're actually asking for something, it should be done as a matter of course. There's no real discretion, I think, for a judge, is the way I read Fortune.
So this was Justice Helm.
Yes.
So you're saying it was so obvious that Justice Helm should have picked up that there should have been a specific unanimity instruction in this case.
Absolutely. Justice Yelm, the prosecutor, defense counsel, it was a failure collectively to do that. And I
Is
think
a failure to give specific unanimity instruction structural error because it really relates to the unanimity of a verdict, which is constitutionally required?
This court has never held that it is
I
structural
understand
error.
that.
I think that that would be wise. It is difficult to get into the minds of the jurors to understand how are they conceiving of evidence, and that is always the difficulty in assessing and probably the proper distinguishing line between what should be structural error and what is not. However, we don't need to go there in this case. There are many reasons why this is harmful error here.
Can't we conclude from this record that it wasn't obviously wrong not to give it because of the way the case was charged and the way the evidence came in? In other words, there are 3 distinct instances as opposed to the type of charge we sometimes see where it's, over 18 months and there's no specificity about when something happened.
I do understand Your Honor's point that in this case there was a rather concrete election, if you will, by the prosecution, even brought forth in the jury instructions. However, there was another important jury instruction that said, and frankly it's one respectfully that's probably given too often in Maine courts, that dates do not matter.
And
then
that
there
should
was-
probably be reserved for situations where there's an actual statute of limitations problem.
Right, absolutely. And it's very difficult when you're a defense lawyer who should be focused on a discrete allegation to focus jurors' attention on that when that instruction is given. And we had really evocative
But is it
testimony.
that much of an issue here to the extent that we're not talking, as it was just referred to, we're not talking about a date range that's over several months. We had discrete periods that were identified at the end of 2001, in January of 2022, and in May of 2022. So the court's suggesting that the focus should be on whether or not the event that was alleged to have occurred in that time frame, narrow time frame, took place. To the extent that that would be the emphasis as opposed to when did it happen?
Well, I think this court said in the Hodgdon decision in 2021, the need for a specific unanimity instruction is not dependent upon the evidence on which the parties themselves seemed most focused. It's what is in the evidence, the totality of the evidence. And there was very evocative testimony in this case about sex with a kindergartner in a parking lot in Hannaford, sex with a second grader in a specific house in a specific town with a penis inside the young girl. That just is much more. The evidence ostensibly charged by counts 2 and 3 pales in comparison to that evocative testimony because it said it was sex on a couch and there was an incident in a truck that arguably there is evidence of an alibi that is corroborated on that particular occasion. And this is particularly difficult in cases of childhood sexual assault, where we have gut-level reactions to these allegations, and we don't want to think about the details.
But the discrete details carve it up to particular events. As you know, the indictment has basically 3 separate incidents. I highlighted them in different colors here, but they stand out. And the evidence is charged, the evidence went in a certain way, it was argued a certain way, referencing 3 discrete dates and incidents that can be identified by the facts and circumstances. That is fundamentally different than an indictment that alleges in or about the year 2015, the defendant committed gross sexual assault, unlawful sexual contact, and the victim testifies, yeah, it just went on so many times I can't remember. Specific unanimity is absolutely critical in those cases, but where it's carved up into discrete events that can be identified separately, doesn't that need disappear as long as it's on or about and it refers to that particular event?
At least under an obvious error standard.
In the mine run of cases, it certainly is a factor that there are discrete, recognized, charged offenses. However, again, we have the instruction, but we also have discrete, very evocative, very gut-level reactions that
fell outside the dates that were specified in the indictment.
Right, but we presume that jurors follow the instructions and the dates don't matter. they were told. And it
No,
was,
no, that's not what they told. They said, I think the instruction, which we've given dozens of times, hundreds of times, is that it doesn't necessarily have to occur upon that particular date, as long as it's within a range of that date.
Right. The question of whether the crime was committed and not when it happened must be the principal
Right,
inquiry,
and that's,
focus of your inquiry.
that's to adopt the on or about language, which it gives a little bit of wiggle room to the state.
Right, but if we have a juror in the deliberation room, in the jury room, saying, that stuff that allegedly happened in kindergarten is really what persuaded me, there is nothing, or in second grade, and that stuff that was really glancingly referenced about sex on a couch, I don't believe that. That was contemporaneous to the time that the complaining witness had motive to fabricate.
Right.
She had a fight with the family. And then in the jury room, there's nothing to stop the juror from saying, I'm going to cobble together a patchwork verdict, and that's what I believe. And you don't, and therefore have a really truly unanimous verdict. And that's really the crux of the need for an instructions like specific unanimity, is that there's never a strategic time to omit one. It focuses jurors on holes in evidence, on the need for particularized evidence.
Well, aren't you really saying that there's a better practice that could be engaged in, but is that obvious error?
Oh, it's absolutely obvious error. This instruction should be given in a matter of course. It's 3 sentences that should be given, and I hope this course will say that. I'm here in a somewhat deja vu position saying this. And think about what it means to not include it in this case. We have very evocative, powerful evidence about kindergarten and second grade that is now admitted not for the charged offenses, that is floating around as 403 and 404B evidence that is...
I don't have the jury instructions in front of me, but did the court not instruct the jury that it needed to make a separate and distinct decision regarding each of the dates involved? In other words, the charges?
Not as to each of the dates involved, Your Honor.
Well, what he did say is that you must consider each charge independently. You may find the defendant guilty of all charges, not guilty of all charges, guilty of some charges, not guilty of others. You must consider the evidence and instructions separately as to each charge and reach a separate decision as to whether the state has proven each charge. And then he went on to talk about the GSA charges, and he specifically in his instructions said he's charged with committing these crimes on or about the following dates, which judges don't always do. But he said, on or about the following dates: December 31st, 21, which is count 1, January 29th, 22, which is count 2, he did say count 2, and May 24th, 22, which is count 3. Judges don't always tie them to specific dates, but in this case, he did.
In this case, he did. However, he also gave the instruction that effectively
understand.
said, don't mind that. You can take any of the dates in evidence and consider that. I see the red light is on. I'll sit down then.
Thank you. Attorney Adams?
May it please the court. There's only one issue that I wanted to touch upon in this protected time, and that's because I suspect the majority of the focus will be on specific unanimity, and it's with regard to the sentencing issue. Just to articulate to the court that there was a disagreement between the parties about the standard of review with regard to that sentencing issue. The state's position is that that was abuse of discretion. The appellant's position is that that issue is reviewed de novo as a misapplication of law. And I wanted to clarify that there are really two distinct questions, and the state's position is that in question 1 was the imposition of consecutive sentences an abuse of discretion. In question 2 was the calculation of the maximum sentence an abuse of discretion. I did, as I was puttering around downstairs, find a case that seemed to analyze these issues similarly, broken down separately. That case is State v. Downs, 2009, ME3. And I apologize for not including that in the brief. I wish I'd found it sooner, but I did just want to touch on that one. And now
Some
I'm
of us
happy to
knew
take
that case
questions.
existed. In fact, my first question was going to be, isn't the issue really governed by Downs? Why, as a prosecutor, would you not, insist that there be a specific unanimity instruction in these cases? What harm is there for the prosecution? All we're saying is you need to agree on each count unanimously.
And I think that this question actually gets to the heart of the issue, that this is not the appropriate venue for addressing whether that should have been addressed, whether that should have been brought up. That question can be more accurately answered before a fact-finding court in a post-conviction review, because there's much more, and as trial counsel, I'm aware of all the things that went on that are not on the record. And so here, it was not requested. The state did not request it, the defense did not request it. The state's position is that it was waived. There is more that
How
might
is this
come to light.
a knowing waiver, though? I mean, to Mr. McNamara's point, is there any, as opposed to our recent decision in Woodard, where we talked about the strategic, counsel actually put on the record that he didn't want to confuse issues too much and things like that when it came to requesting self-defense instructions. How is there ever a strategic decision that would leave defense counsel to waive intelligently and knowingly a specific unanimity instruction?
Well, I think there is some evidence on this record of defense counsel's trial strategy that goes to why that may not have been the focus and why defense counsel did not elect to request that instruction, because defense counsel did request a different instruction about the defendant's decision not to testify. The defendant also didn't file any motions to limit the introduction of prior bad acts, and was heavily focused on the authenticity of the recording and on the veracity of the victim.
But as defense counsel, I mean, you often have, I mean, it didn't happen, but still, you still wouldn't waive an appropriate instruction to say, but if you disagree and you believe these victims, let's be clear, you have to, unanimously agree on the incident.
I can't get into what was on the mind of defense counsel, but I can say that looking at the record, there was a very clear defense strategy throughout the trial that comes through strongly.
I assume you think it wasn't obvious error in any event if we decide that it was, that is the appropriate standard.
In any event, and yes, I noted Justice Lawrence's question about a best practice, and I actually had written in my notes that there's a difference between a best practice and a plain error affecting substantial rights. Do I think that specific unanimity instructions in any cases would be a best practice? Yes. And in fact, I think that there are many cases that don't include generic testimony where the jury does need a little more instruction on a unanimous verdict. However, I don't
And hopefully you'll change your practice going forward on these issues, as will other people. But go ahead.
Well, again, there's more that happened behind the curtains.
Without getting into this case, then, just hypothetically, give us an example of a strategic reason why the defense counsel would not want to have a specific unanimity instruction given by the court, whether the counsel argues that point to the jury or not.
Well, I think in this case, defense counsel may not have wanted the jury to focus at all on the dates, but on generally, was this victim being truthful? And I can tell, from appellant's counsel, he's reading the transcript. This court is reading the transcript. During the trial, what was characterized as this evocative testimony by the victim was really a minor part of the trial. Most of the trial was focused on this recording, which was played in its entirety 2 times. It's a 15-minute long recording. And there were 2 witnesses who testified about the authenticity of the recording, who testified about, I don't want to say tinkering, but enhancing the recording so that it could be heard more audibly. That was the focus. And defense counsel may have thought, we don't need a specific unanimity because we don't want the
But
jury.
you say may have thought, and isn't waiver an intelligent knowingly giving up that right?
How could we know that in this?
Well, that's my point. Is a simple failure to request and then a general sure the instructions are okay, should that ever really be a waiver in the heat of a trial? As opposed to obvious error. Nobody's saying it's preserved.
Yes, I would say yes. I would say we should trust defense counsel to be making these decisions.
Wouldn't a waiver look like the prosecutor or the judge saying to defense counsel, do you want a specific unanimity instruction? And defense counsel saying no. Then we know, right, that there was a strategic decision as to whether or not, but you're asking us to sort of speculate, right, as to why defense counsel didn't make an objection or make a request.
Well, I think the suggestion is actually that this court should speculate that it wasn't a knowing waiver. And that is why this is an issue that would be more appropriately addressed in a post-conviction.
Doesn't that just get rid of obvious error then? I mean, obvious error is the failure to request an instruction or failure to object. I mean, are we going to assume that every time defense counsel, or for that matter, a prosecutor doesn't object, that that's a waiver as opposed to reviewing it for obvious error?
Well, I believe the case law actually says that trial strategy will not always be apparent on the record, and that even when it isn't apparent
Well,
on the record.
that's if it's trial strategy. In other words, if there's testimony at a post-conviction hearing, for example, that it was a matter of trial strategy. But it so happens that Attorney McNamara and I were both involved in a 2020 decision of this court called State versus Thurlow. It was a trial in which I presided, a jury trial in which I presided, and the attorneys, both in chambers, on the record before closings and at sidebar after closings, assured me that there were no requests for further instruction. But this court decided that I had neglected to give an instruction on, as I recall, it was had to do with the inference regarding intoxication, and there was definitely no waiver, but it just seems to me that decision stands in contrast to the state's position here, meaning that the failure to request an instruction, at least in the case that I am thinking of, was deemed obvious error. I'm not saying that this is obvious error, but I think we need to slam the door on the idea that a forfeiture, which is a failure to request something, can be equated to a waiver, which is an affirmative, knowing relinquishment of a known right, I think we've said.
And I think to even get to that point, you have to start with the premise that a specific unanimity instruction was required in this case, or should have been contemplated, but this case is different because there were specific dates alleged in the indictment, there was specific testimony.
Right.
And that's getting to the issue of whether it is obvious error in any event.
Right.
There's the fact that there were specific dates and the jury was told to focus separately on each charge, and therefore each date tends to eliminate any possibility that the jury had to speculate on which of the events described in the evidence related to a particular charge, which is really the justification for specific unanimity, isn't it?
Right. And the appellant has focused on how there was mention of other instances that fell outside of those dates. But I looked through the court's jury instructions, and the court repeatedly referenced the May 24th date, which was also referenced in the indictment. It was it was referenced by me as trial counsel in my closing statement. It was referenced again and again, that May 24th date. And so there's really no reasonable basis to conclude that the jury voted on or considered any date other than May 24th, or thought that they could have considered any date other than May 24th.
I take it from your comments that you would not object to defense counsel requesting a specific instruction, even in a case where there are discrete events, that it's you're going to let them have that under any circumstances.
I absolutely would not have objected had it been requested.
And that would apply to other cases going forward if there's even if there are specific dates that are alleged and the court treats it the same way, defense says, I want a specific, instruction here, you would say, fine with me.
Correct.
Okay.
So let's give you time to deal with the second issue. Is there anything more you wanted to say on the sentencing and whether it was done properly in double counting? So if in rebuttal there's something you want to rebut as to what the AD is going to say.
The only thing I wanted to say is that it was not an abuse of discretion I thought that this sentencing judge very beautifully went through the sentencing calculation, both with respect to imposing consecutive sentences and the maximum. He sentenced this defendant very creatively to achieve the sentencing goals and repeatedly referenced that this sentence was going back to those sentencing goals, repeatedly referenced the statutes, and that was done appropriately. There's been
And so
no
it was not
misapplication
double
of the law.
counting because,
It was not double counting, well, for many reasons, but first of all, it's two issues. It's an issue of whether the sentences could have been imposed consecutively. There was no abuse of discretion there. The court stated they were so serious that that warranted a sentence in excess of the maximum 10-year sentence. In the second step, the Huey analysis, the next different section of the statute, different analysis, the court then took into account the fact, and I, in my brief, referenced this as criminal history. I think rereading it, the judge was actually getting a few things. The judge was getting at the fact that there was a cumulative effect, which is what the Downs case discusses, the cumulative effect of the offenses, but also there was a cumulative impact on the victim, subjective victim impact, which comes through in the phrasing that the judge used about that this was the second time that the defendant had committed this act against this victim. And so again, there was no abuse of discretion in that analysis either.
and to the extent that opposing counsel is going to suggest that the court was utilizing the seriousness factor and double counting it in that respect, what's your response?
I just don't think that's an accurate reading of the sentencing court's analysis whatsoever. The court very clearly was considering multiple factors as laid out by the legislature.
So when a person's jury verdict is on multiple counts, you sentence on the first one, then you get the second one and there's a prior conviction for the same activity. Ooh, there's two priors, and just keep mounting them up until you get to count 12 and say there's been 11 prior incidents?
Well, if in this case there, over a period of time, I do think there is a cumulative impact that should be taken into account. And to not take that into account would be, in effect, to give somebody a sentencing discount just because they've gotten consecutive sentences, which also would not be a correct application of law.
Thank you.
Thank you.
Attorney McNamara, can I start where we just ended? In other words, on the sentencing, since we didn't talk about that at all, I think, in your original argument. Under State versus Downs from 2009, we specifically affirmed and agreed and said it was appropriate to enhance at set 2 of the Huey analysis because it is a re-victimization of the same victim. And then also to use that same factor, the seriousness, the multiplicity of the amount of the crimes, as a factor for consecutive sentences. Why is that not controlling?
Well, I don't think it's controlling because what we're talking about here is the propriety of a sentence, which is different than the legality of a sentence. We're focusing on things like minimizing correctional experiences, providing notice to individuals, the idea that somebody can be rehabilitated outside of prison, and counting things, also the appearance of fairness. And that's an important one. When judges are saying, I am counting the fact that there are multiple crimes here, over here, and then I'm turning around and counting it over here, I think that is going to rub people, observers, in the wrong way.
But this is, as was pointed out, this is a case where there's the same victim, and it's a re-victimization. If you had someone who committed like serial burglaries over different places, different times, and the judge did the same thing and said, well, you convicted of 12 counts of burglary, and you get to number 8, and you say, well, you have 7 prior convictions, that ramps it up. That would be maybe troubling. But in this case, as was pointed out, it's re-victimization. And that's how it gets counted as an aggravating factor sequentially.
I didn't read it that way, Your Honor. I read it as a statement as you have convicted this crime previously, not as a subjective impact on the victim. And that's maybe something that would be appropriate for remand to see what the judge actually meant by that. But I think there is an important distinction there. I agree with the
Didn't we hold in Plummer, in a slightly different vein, but didn't we hold in Plummer that certain facts can come up as different factors in the sentencing process? Isn't that really what you're talking about here?
As long as they're considered in different ways. If one is considered objectively, if one is considered subjectively, perhaps they can. I don't read this as that being the case. I read it as both a statement twice that he has committed multiple
I'm intrigued
crimes.
by your argument that that's a propriety issue as opposed to a legality issue, since Plummer does say that, we review double counting claims de novo as a legality issue. So.
The Plummer case does, and I'm trying to remember whether the Plummer case was a sentence review case or whether it was a direct appeal of the sentence. I think, at base, there is a legal aspect and a propriety, and it is on that line, no doubt about it. But to answer your question as to why it's different than Downs is because we're focusing here on the propriety. And I agree. Oh, I'm about out of time.
You are. Thank you. All right, thank you, counsel. This is our usual practice. We will be taking the matter under advisement. We will issue a written decision in due course. And with that, I think we're in recess, and we're in recess for the lunch break.
All rise. We are in recess.